Lease agreement TRLI 2001B equipment lease agreement. Section 12 reports and inspections. Section 12 1. Duty of the lessor to furnish on and before July 31st of the 2002 and or before each of the July 31st thereafter, the lessor will furnish or cause the manager under the management agreement to furnish the leaser owner participation loan and participant and indenture trustee and the rating agency an accurate statement as of the preceding March of 31A, showing the amount of description and reporting markings of the unit and lease hereon under the amount of the description and reporting markings of all units that have been suffered as an event of loss during the 12 months ending of the such March 31st, or and since the closing date. In the case of the first, such as the statement and of such of the information regarding the condition or repair of the unit as a leaser may responsibly request a B, the stating that in the case of all units repainted during the period covered by any such statement, the markings required by the section 4.2 here and under here shall be preserved or replaced. C, showing that the percentage of the use of the United States and each of the Canada and Mexico based on total mileage traveled by all railroad cars and total managed fleet by other units, if any, and an extent generally may be available to the manager in ordinary course with respect to the railway cars and the general interchange service similar to the units for the prior calendar year as reported to the manager by the railroads, provided that the lessor shall be cooperative with the owner participation and the leaser shall be provided such an additional information on such matters of the owner participation. The leaser may be responsible request to the owner of the participation of the leaser to pursue, the fulfill, in their respective tax audit and tax litigation rights and obligations. And D, stating that the lessor is not aware of any of the conditions of any of the units which causes the unit not to comply in any of the material respect with the unit's regulations of the FRA and interchanging the rules of the field manual of the AAR as they apply to the maintenance and operation unit interchange and any of the requirements here and under. Section 13.2, leaser's inspection rights. The leaser and owner participation in indenture trustees shall have the right, but not the obligation at the respective sole cost of expense, and unless the lease event of default shall have occurred, and continuing by their respective authorized representatives to inspect the units, all subleases there and lessors recorded with respect thereto, and all inspections shall be conducted by the lessor's normal business hours of the manager's premises or in areas that are not in premises of the subleases or sublessors to the lessor have responsible access, and upon the responsible prior to the next notice of the lessor shall not be liable for any of the injury to the death of the person exercising either on the behalf of the leaser, owner, participation, indenture trustee, or any other prospective user the rights to inspection granted under the section 13.2 unless caused by the lessor's gross negligence or willful misconduct, except for the following occurrence continuing with the lease event of the default. No inspection pursuant to the section 13.2 shall interfere with the use of the operation maintenance of the units or accordance to or ordinary course of the lessors and any sub-lessor's business except for this provided herein. The lessor shall not be required to undertake and incur additional liabilities in connection thereof. 2. Section 14, lease events and default.